This is Bloomberg Law with June Grasso from Bloomberg Radio.
From where I'm standing, I could see him through the window, and then he just kind of turned to my right, and then he fired about 10 to 15 shots. Well, when we heard the shots, we kind of all just dropped to the floor and flung ourselves into a corner.
16-year-old Lila Sayarith had been sitting next to Colt Gray in a math class just before the shooting that killed 2 students and 2 teachers and injured 9 others. The shooting at Georgia's Appalachia High School last week is the 23rd school shooting this year and the deadliest.
In essence, you are charged with 4 counts of felony murder, as outlined in the state warrants that have been issued against you.
14-year-old Colt Gray has been charged with 4 counts of murder. And for only the second time nationwide, his father is also being prosecuted for the shootings. Colin Gray has been charged with 2 counts of second-degree felony murder, 4 counts of involuntary manslaughter, and 8 counts of cruelty to children.
The maximum penalty for each count is up to 30 years imprisonment.
Barrow County District Attorney Brad Smith says there's no broader meaning behind bringing charges against the father.
I'm not trying to send a message. I'm just trying to use the tools in my arsenal to prosecute people for the crimes they commit.
Joining me is Ekow Yankah, a professor at the University of Michigan Law School. They charged the father right away. Do you think the speed is because there was sort of a precedent already set in the case against the parents in the Michigan school shooting?
You're right to notice the speed at which they charged the father. It is one of the things that shows that we're entering into a new legal world. As you point out, the Ethan Crumley case in Michigan, where the parents were convicted, was considered precedent-setting and path-breaking, but it doesn't take long for a case that was seen as utterly novel to be in a prosecutor's back pocket and result in charges in, just hours in the next set of egregious, horrible cases. But it shows you that what was completely novel becomes a ready-made tool for the next case.
The charges against the father in this Georgia case are more severe than in the Crumley case. There, the parents were charged with involuntary manslaughter. Here, the father is not only charged with involuntary manslaughter, but also with 2 counts of felony murder for the deaths of the students. Do murder charges against the father seem like a stretch here?
These are charges that see yet another step forward in holding parents accountable to hold that they're directly responsible. Involuntary manslaughter is typically related to somebody's recklessness or negligence that caused death. Second-degree murder is a stronger claim that, in some sense, you killed somebody even without premeditation. As you know, Georgia's murder laws are somewhat idiosyncratic, and so those second-degree murder charges look to be attached to the idea that his son killed 2 children, and thus the cruelty charge to children is a second-degree murder. But as a general position, it stands for prosecutors being even more aggressive in saying that this father didn't just recklessly lead to this death, but that his actions in some serious way caused these deaths.
In May of 2023, the father and son were interviewed in connection with online threats to carry out a school shooting. But the teenager wasn't arrested because authorities couldn't connect him to the online account. At some point after that interaction, Gray bought his son an AR-15 style rifle. Do you think that's going to be a main focus of the prosecution? You had a warning in this conversation, and then you went and bought him a gun.
Yeah, it sounds much like the cases we've seen that came before. It's these set of horrible and gut-wrenching facts. The facts that give you a feeling as though a parent not only ignored a child who was crying out for mental health help, not only ignored a child who is fascinated with violence and school shootings in particular, but instead of steering this child away from these kinds of things or securing your weapons, you have parents in both cases, but in particular in this great case, who not only metaphorically, but quite literally put the gun in the child's hands, goes and buys them a weapon and arms them. And it's those kind of egregious facts that lead prosecutors to eventually seek direct responsibility. Now, I'll say in many parts of the country, one of the reasons we really care about trying people in front of juries is that different communities will have very different relationships to these moments. So there are just lots of communities where a father buying a gun and taking their son hunting seems like a perfectly ordinary part of the communal experience. I teach cases where courts come to very different decisions because there are very different communal norms on what counts as negligence with a gun. You know, one of the cases is a Georgia case where the judge says, in Georgia, we have a long and proud history of hunting. And in other communities, this is close to unthinkable. And so I don't think the facts are without anything for a defense lawyer to point out. But when you have a child who's so troubled, who's so fascinated with violence, it's not surprising that we all are outraged when a father, instead of making sure guns are away, arms the child with essentially a rifle that's made for war.
In the Crumbly case, there was a lot of evidence that the parents ignored their son's deteriorating mental health. In the case of Colt Gray, there also seems to have been contact between the family and the school about his mental health. We don't know that much about the facts at this point, but the mental health warnings are sure to be a big part of the prosecution's case against the father.
Look, even among trained psychiatrists, they will tell you that it's very hard to predict when a patient is actually going to resort to violence, when there's a gap between fixation, fascination, mental health issues, and actual action. That being said, you know, part of what drives these cases is that there are particularly egregious facts. So, for example, when this mother took him in seeking mental health help, apparently, and we're all finding out the facts, but her notes said something like he should have been in therapy for months now. He deeply needs help. And so it's those facts on the ground that parents themselves did see or could have seen this coming. Indeed, the latest reporting shows that when he texted her, she immediately called the school because she was afraid that he was going to resort to violence. You know, you mentioned earlier that this father was arrested quite quickly. So I think one of the things that we're going to see developed at trial is not only what was the reported incident beforehand where he posted about school shootings, how much was he fascinated with school shootings, how much did parents have reason to know about his fixation with violence, and frankly, what kinds of things did they discover in their investigation or in their interview with him that would lead to such quick charges. And so, you know, alongside the rest of the country, I'll be waiting to find out exactly who knew what when. What did he say?
As you mentioned, the mother called the school to warn them about her son. Could a possible defense for the father be, well, the school didn't act quickly enough?
Yeah, I don't think that'll be much of a defense for him at his criminal trial, especially because he's not the one who acted. From what the reporting is now, it seems like a horrible set of missed opportunities. A school counselor went to see if he was there, mistaken him for another child with a similar name, and took a backpack of the wrong child. So it's all these sort of horrible missed moments after missed moments that lead to the death of 4 people. I do think the real question will be whether or not those moments play into further civil liability for the school. As you know, in the Oxford shooting in Michigan, the Oxford school system was eventually not found liable for any negligence on their part criminally. But that doesn't settle the question of whether or not those individual parents and injured people will think that the school missed its own duties to protect them.
Some critics say that charging the parents is a misguided effort to make parents the scapegoats, while lawmakers fail to pass gun control legislation.
I think that's right. I mean, look, I think in some sense these are not the exact same question. I am cautious about the way in which we treat every social problem as though it's a criminal law problem. But I don't pretend to have an easy answer about whether or not parents who are so grossly negligent or so reckless should be held liable. You know, it goes against a long-standing criminal law principle. The principle that I taught just last week to my criminal law students in their first week is that you're not responsible for the actions of others. You're not responsible, barring a very few exceptions, for accomplice liability or felony murder. But yes, extraordinary cases are going to push that intuition. The real point is whether or not you think this parent should be culpable. It's clear to me that what needs to happen is the way we treat our society that's saturated in guns. What do we think about gun regulation? What do we think about red flag laws? And what do we think about safe storage laws? In Michigan, it was only after the Crumley shooting that we passed the first set of gun regulations, including safe storage laws, in 4 decades. So as heartbreaking as this particular case is, and whatever one thinks about what should happen to this father, it seems to me a kind of hopeless mission to think that we're going to solve this never-ending social problem of school shootings by prosecuting one parent at a time. And if legislatures are going to think that we have our anger sated by essentially, blaming one parent at a time or bringing the hammer down on one parent at a time, locking up a parent here, a parent there, while forever telling us that we'll think about gun regulation in some other time, then we're going to keep visiting these tragedies.
The prosecutor said he wasn't trying to send out a message by charging the father, that he was just using the tools in his arsenal. But he gave a full press conference after the first court appearances. Isn't there a message here?
Prosecutors are people too, and they live in these communities, and they are heartbroken and devastated when these things happen as well. And so I believe that when a prosecutor looks at something like this, they are, like all of us, outraged and think, I want to hold somebody accountable. But no, ultimately, of course, part of what prosecutors do is use the law as a tool for sending a message to what they believe is unacceptable behavior, what they believe their community wants to hold as a line of accountability, and even what they think matters for their own views of the law and even their own ambition. I don't think he's necessarily cynical or lying, but it's too much to believe that a prosecutor wouldn't think that this kind of immediately nationwide visible case wouldn't send a message.
Do you think this is the second case charging a parent with many more to come?
I understand why a prosecutor would want to hold parents like this accountable, but I do think we shouldn't be so cavalier about what it means to hold parents accountable for the behavior of their children, and in particular, what it will mean when the next case is not as egregious and prosecutors still use these tools to prosecute a case. And the overwhelming majority of our cases, something like 95%, are plea bargains. And so every time we empower prosecutors to threaten people with further criminal liability, we're also giving them the power to exact a huge number of guilty pleas that will never see a jury or a reporter.
Thanks, Ekow. That's Professor Ekow Yankah of the University of Michigan Law School. A note, Michael Bloomberg, the founder and majority owner of Bloomberg LP, the parent company of Bloomberg Radio, is a donor to groups that support gun control, including Everytown for Gun Safety.
I couldn't agree more with President Biden. U.S. Steel should remain American-owned and American-operated.
It was no coincidence that while courting union voters in the crucial battleground state of Pennsylvania, where U.S. Steel is headquartered, Vice President Kamala Harris announced her opposition to Nippon Steel's $14.1 billion takeover of the iconic American company, a deal that the U.S. Steelworkers Union vehemently opposes. The proposed deal is under review by the secretive Committee on Foreign Investment in the United States, or CFIUS. Of course, Biden already announced his opposition to the deal back in March. And in April, at the United Steelworkers headquarters in Pittsburgh, the president made this promise to the union workers.
U.S. Steel has been an iconic American company for more than a century, and it should remain a totally American company. American owned, American operated by American union steelworkers, the best in the world. And that's going to happen, I promise you.
Several business groups, including the U.S. Chamber of Commerce, sent a letter to Treasury Secretary Janet Yellen on Wednesday, warning that the administration's national security review of the deal is being used to further political agendas. Both Nippon Steel and U.S. Steel have suggested they may challenge an adverse decision in court. Joining me is Rick Sofield, a partner at Debevoise Plimpton. He was formerly the Justice Department's CFIUS representative and participated in the review of more than 1,000 transactions. Rick, CFIUS has yet to make its recommendations, but in March, President Biden announced his opposition to the deal. Is that unusual?
That's very unusual. To my knowledge, President Biden's statement was made even before a filing had been made with CFIUS. And that's not how the process ordinarily works. Ordinarily, a filing gets made to the committee by the parties. They usually do that together, and CFIUS evaluates the transaction using what it calls a risk-based analysis. And that risk-based analysis looks at the threat posed by the foreign investor, the vulnerability of the U.S. business, and the consequences if a threat actor were to take advantage of a vulnerable U.S. business. And so looking at the threat, vulnerability, and consequences altogether, CFIUS comes up with its overall risk assessment and bases its recommendation to the president on that risk assessment. So back in March, to my knowledge, CFIUS would not have completed a risk analysis. And so the president really wouldn't have had the benefit of that insight from CFIUS in making his pronouncement. There had been no risk analysis. And to me, frankly, that creates potential litigation risk because parties to the CFIUS process are entitled to due process. And it's hard to see where there would be adequate due process, which is the notice and opportunity to be heard, meaningfully heard on an issue, how they could have had due process if the president had already made a decision before the committee had done its work and done its risk-based analysis.
In late August, as first reported by Reuters, CFIUS sent a letter to the companies warning that their proposed deal would threaten U.S. national security by weakening the country's steel supply chain. What can the companies do to change CFIUS's mind or allay its concerns?
So it sounds like what the companies got is what CFIUS colloquially calls a Rawls letter or a due process letter. This has become a pretty routine part of the CFIUS process over the last decade or so. And really the rationale stems from litigation involving a company called Rawls that was building a wind farm in Oregon. And CFIUS was concerned that the wind farm could be used to house listening devices that would spy on a naval training base near the wind farm. And so CFIUS moved to block that transaction. The parties to that transaction sued and said that CFIUS's decision was not based on due process and actually invited the court to review the president's determination. What the court did there is it reaffirmed Congress's mandate in the CFIUS statute that courts should not stand in the shoes of the president and do their own national security assessment. And so the court didn't say that the president got the national security decision wrong. Instead, what it did is it said, hey, CFIUS, you need to go back and check and make sure that you gave the parties adequate due process. You gave them all the information about what your concerns are and gave them an opportunity to be heard on those concerns and to see if there could be some package of mitigation measures that would allay the national security concerns short of a block. So that's what seems to be happening here, is CFIUS has now communicated specifically what its national security concerns are. And, I would assume what's happening now is the companies are, now that they understand what the concerns are, trying to convince the government that those concerns can be addressed in some way short of the president blocking the transaction.
Nipon sent a senior executive to Washington this week to meet with White House officials about the deal. Would you call that a last-ditch effort to save the deal or just part of the process?
I mean, CFIUS has already said they have concerns they don't think they can mitigate. And so, normally in the process, that doesn't necessarily mean the decision's done, but it's kind of hard to get them to change their mind if they've gotten this far. So, maybe you could call it a last-ditch effort, but it is part of the process, right, where CFIUS gives a written description of the concerns and then the parties have discussions to try to address it.
Talking about due process, the companies were reportedly only given something like 5 days to respond to CFIUS's letter about national security concerns. And according to the Washington Post, the companies had written to CFIUS asking to withdraw their submission, which would start the clock over, but CFIUS never responded. Are those things that might support an argument of a lack of due process here?
They could. CFIUS is usually pretty liberal about granting companies an opportunity to withdraw a filing and to refile it, to stretch the clock and continue discussions on whether a package of mitigation measures can be constructed that would be adequate and appropriate to address the national security concerns. So it is abnormal, in my view, for CFIUS to not allow the parties to withdraw. And that's especially true in a transaction like this where the deal hasn't been completed. If we were in a situation where CFIUS was reviewing a transaction that had already occurred, then the national security harm would be accruing every day. And CFIUS may choose to act quickly in that case to stop the national security harm from occurring. But here the transaction's not done. And so it's odd to me that CFIUS wouldn't give the parties an opportunity to take the time to put together some meaningful proposals on how to address the government's risk concerns.
If the companies decide to challenge a decision blocking the deal in court, what are the risks to CFIUS from a proceeding like that? I mean, would the Supreme Court's recent elimination of the Chevron doctrine and its deference to agencies play a part?
So this is a really interesting question. Firstly, the Rawls case that I referred to earlier, it kind of gave a guideline of how the court might think about due process. And so I think certainly here there could be some due process arguments, particularly in light of the fact that, the president put his thumb on the scale back in March before any record had been put together. And so I think that can really call into question whether or not there has been due process here. The decision might have been made before the transaction was even filed with the CFIUS committee. And so I think that can put the government in a very difficult position if due process arguments are raised in the courts. Now, on the issue of what effect the overturning of Chevron deference might have, I do think this is a tougher argument, but maybe not an impossible one in today's environment. And that is, Congress has said that the courts should not put themselves in the president's shoes and assess national security risk on their own, that the courts should defer to the president's authority in this space. And deference to the executive branch, to the president on national security matters, it's a longstanding precedent. It's a longstanding deference. And it's for good reason, right? The president has the benefit of inputs from the intelligence community that the courts just don't have. And so to kind of attack that longstanding deference, I think that's an uphill battle. That said, though, we have this trend that we're seeing in the courts away from giving deference. And so, that could impact the court's thinking here, particularly if we're in a circumstance where there's a really weak administrative record, where there are significant due process concerns. That could invite the court to go further than just pointing to due process fouls and to potentially somehow put guardrails around or curb the president's supreme authority to make national security determinations through the CFIUS process.
That would be a first then, right?
Absolutely would be a first. But, there's a saying in legal circles that you've probably heard, which is bad facts make bad law. Mm-hmm. If you've got bad facts, you've got a bad written record. You've got a record of sort of the decision maker making a decision months before the matter has even been put before him. And then, the supporting documentation is not convincing, that the parties are not given an adequate time to prepare responses to the government's written concerns. And you have all these factors pointing to perhaps a precipitous decision by the government. You could be inviting the courts to take aggressive action. And so, yes, I think it would be novel for sure. And I think it would be a hard argument to make and win to challenge the president's national security determination. But if you give the court a bad enough record, they just might do it.
Thanks so much, Rick. That's Rick Sofield of Debevoise Plimpton. As we've been discussing, Nipon and U.S. Steel have been making last-ditch efforts to save the deal. This week, they unveiled correspondence with the United Steelworkers to show how union leaders snubbed their efforts to negotiate an agreement. And U.S. Steel warned that plants could be shut down if the deal falls through. Their strategy appears to at least have bought them some time. The Washington Post is reporting that a decision on blocking the deal may not be made until after the presidential election, though Biden remains opposed to it. Coming up next, 7 years and they still haven't decided who gets the engagement ring. This is Bloomberg.
If you like it, then you should have put a ring on it. If you like it, then you should have
And if you do decide to put a ring on it and then the engagement is broken off, who gets that ring? Well, it depends. And that's why a fight over a $70,000 Tiffany engagement ring has reached Massachusetts' highest court. Bruce Johnson called off his engagement to Caroline Citino in 2017 because he suspected she was having an affair, which she denied. He took her to court to get the Tiffany engagement ring back, but a judge found that he was mistaken about the affair, so she could keep the ring. That's because in Massachusetts, since 1959, an engagement ring is considered a conditional gift, and the gift giver is entitled to its return as long as that person was not at fault for calling off the wedding. But then an appeals court reversed the trial court, finding that Johnson may have had other reasons besides the alleged affair to call off the engagement. So he gets the ring back. But not so fast. Now, Massachusetts Supreme Judicial Court will get to make the final decision on who gets the ring. Even though the justices seemed a bit uncomfortable or even silly deciding who was at fault in the relationship, as Justice Scott Kafker said.
I mean, we seem to look silly trying to do this, either under your justification or your fault analysis, because it's so indeterminate who's at fault for not going forward with the marriage, right?
And some of the justices questioned why an engagement ring should be given a unique legal analysis, unlike other gifts. Here are Justices Dahlia Wentland and Kafker quizzing Johnson's attorney, Stephanie Taverna-Seiden.
But if it was a tennis bracelet?
Yeah. Or a car.
Yes.
I agree. I think all of those...
Why is it the ring?
Well, the ring has special value in our society. Traditionally...
But no one wants to keep the ring. I mean, the ring is no longer a symbol of love. It's a symbol of, that the thing broke down.
Unless it's worth $70,000.
Exactly, and that's what Cooper v. Smith said.
Then it's cash. It's not that the ring has any value. It's that the ring is worth a certain amount of money.
Joining me is Rebecca Tushnet, a professor at Harvard Law School, who's an expert in intellectual property law and engagement rings. Rebecca, most states now follow no-fault rules when it comes to returning engagement rings, but Massachusetts follows a fault rule.
Yes, the most recent case on point, exactly on point, is that it's fault-based. There are old cases saying that fault matters. I think there's a reasonable argument to be made that they might have already adopted the sort of modern no-fault view in some ways, just by adopting no-fault divorce.
The trial court here found that Bruce Johnson was at fault, and so Caroline Citino could keep the ring. But then the appellate court reversed, finding different facts. But isn't the trial court the finder of facts?
So this is why many courts retreated from the idea of fault in relationships, because it's not actually very easy to say, what is legally wrongful or, when you're entitled to break up with someone. Courts have become increasingly unwilling to say you're not entitled to break up with someone just because you don't want to be with them.
Yeah, and when they say at fault, is it fault if you call off the engagement, or is it more than that?
So you're not supposed to call off the engagement without a good enough reason. So, the temptation of a no-fault rule is that you don't have to make those judgments.
At the oral arguments at the Supreme Judicial Court, Citino's attorney argued that Massachusetts should follow Montana's law, which is a no-takebacks approach. Is Montana the only state with a rule like that?
So I think it's the only one where the state Supreme Court has adopted that rule, and I have to say, citing me, so I'm very happy that they did that. It's just like any other gift, right? So, if you gave someone a car while you were dating, you don't get to take it back just because you broke up. But it's also, one of the very few cases to decide anything on this since, the 80s. There just aren't a ton of state Supreme Court cases about engagement rings.
Johnson's lawyer argued that the ring should be treated as a conditional gift and it should be returned to the giver regardless of who's at fault. Is that a rule that many states follow?
Yes. In many states, they made up a special rule just for the engagement ring. So it's actually not the usual rule for a conditional gift even. So the usual rule for a conditional gift is that the donee can keep it as long as they remain willing to perform the condition. And so if, your parents say, I'll give you a car if you go to law school, and you go to law school and you remain willing to go to law school, they can't take it back even if they change their mind. But for the engagement ring, the condition is actually the marriage actually happening. And so even if the donor unilaterally decides, I changed my mind, they can get the ring back. So it's fair to say it's conditional gift, but it's useful to point out that it's not really the conditional gift rule for everything else.
Why have the courts been treating engagement rings different from other gifts that might be as expensive?
So I have argued that it's a legacy of sexist ideas about gold diggers that got run through various stages of legal development. So courts initially said, well, the ring goes back if the woman was at fault, that is, if she was a gold digger, basically. And then, as no-fault divorce arose, courts started saying, well, look, if getting divorced isn't a question of fault, then breaking off an engagement can't possibly be a question of fault. In fact, you did everyone a favor by not getting married, if it wasn't going to work out. And so once you do that, you want to have a no-fault rule for other aspects of the premarital relationship. And then there's just two possibilities. You could have a no-fault rule where everybody just walks away, or you could have a no-fault rule where the gift always goes back. And they somewhat surprisingly chose the no-fault rule where the gift always goes back. I think that's because of this sort of history of suspicion of women.
And you favor the no-take-backs approach.
Neither approach is exactly how sort of ordinary people are likely to think about it. Like, people do think that there is such a thing as fault in relationships. But the courts have, in my view, wisely decided it's really hard for us to do this. It's not a good thing for a legal system to try and do. And so you have to choose between two situations or two rules that aren't perfect, that don't match up with people's, intuitions about morality. And I think the one more consistent with our goals for a legal system is you just walk away, that gifts stay where they're given.
The justices seem to be dismayed about delving into the details of this messy romantic relationship. Justice Scott Cathcart said, this old rule seems old-fashioned and kind of silly. And Justice Dahlia Wendlandt questioned if the ring was different from any other gifts. She asked, what if it was a tennis bracelet? Why is it the ring? Do you think that the court will make new law here?
So, I think in the sense that the possible rules are reasonably clear, and we have examples of all of them. So my guess is that they won't keep the old Massachusetts rule, but some of them may be attracted to the idea that there's a special set of expectations around the engagement ring, as opposed to a car or a tennis bracelet.
I mean, would you be surprised if the Massachusetts Supreme Court didn't change the rule, just left it as it is?
Yeah, I think I would. This is classic common law material where, the job of the court is to make sure that the common law evolves and reflects, current situations and understanding.
And do you have any feel for which way they'll go?
I have my own preference, but I wouldn't say I have any feel. I think in general and in relationships, you get what you get. And so I would favor a rule that says, we're not going to go back into any of the gifts and reallocate them. If you gave a gift, it stays a gift. So I just don't think the conditional gift framework works very well. This is an example of the ways in which the rules for living may not be reducible to legal rules, right? That there may be plenty of conduct worthy of judgment in relationships that courts still shouldn't be judging.
The parties have been in litigation for close to 7 years. I mean, with all this litigation, it seems like it might be more expensive than the $70,000 ring. Is there more to this?
I don't know the parties in any way, but this is actually one of the things motivating the courts from withdrawing from fault in most relationship situations, which is, they don't want to be deciding these cases because, of course, there's lots of motives that are non-monetary, right? The relationships are intimate and, you're dealing with a lot of emotions and it's just a very difficult situation. And, it's awkward to look at that and say, okay, who's the one who's really to blame for this relationship falling apart? When, frankly, your usual reaction is these people shouldn't be together.
It seems like the engagement ring should be something that's addressed if there's a prenup.
So certainly that. And, it's also useful to remember that, of course, most broken engagements don't end up in court. And, usually people live with whatever happens, including, many times a woman will give the ring back because it does have symbolic meaning. But my interest in this situation came about after I read a case where the man and the woman were at a bar. They got in a fight and the man hit the woman. The woman, quite sensibly, stomped out. She threw the ring in a field and didn't want to see him again. And she was held liable because of the no-fault rule for the value of the ring. And that just seemed wrong to me.
Are there cases where after marriage, let's say in a divorce, there's a fight over the ring?
So this is a classic legal fiction. So at the moment you get married, the ring retroactively becomes a gift that was given during the engagement, and therefore it enters into the marriage as separate property of the woman.
That really is a legal fiction.
Yeah, it's quite wild. So if you're married for, 2 hours, the ring is yours.
And these cases over engagement rings are the last vestige of litigation over broken engagements?
Yeah, so most states abolished by statute the Hartbaum torts, breach of promise to marry, alienation of affections, criminal conversation, and seduction. Criminal conversation is a great one. It means having sex with a married woman. And so they abolished them by statute, and then basically men used conditional gift theory to say, I'm not suing for one of the Hartbaum torts. I'm suing, on basically a contract theory. And many courts allowed that to proceed despite the abolition of the Hartbaum tort. And then that became increasingly weirder as all states adopted no-fault divorce.
This has been fascinating, Rebecca. Thanks so much. And we'll see what the court decides here. That's Harvard Law School professor Rebecca Tushnet. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.